Hello and welcome to Trial TV Live. I am the squeegee of justice. Got little Roger or little Ralph over there looking to go out. Welcome in everybody. We are in day 13 of Utah versus Kouri Richins. Let me just make sure my audio is okay before we continue on. Welcome to Trial. Sounds good. All right, grab a seat, get comfortable. Let's get to it. And good morning, everybody. How's everybody doing today? We are in day 13 of Utah versus Kouri Richins. Detective O'Driscoll is on the stand still. Theoretically, he should be the last witness for the state before they rest their case in chief. He was under cross from Miss Nestor when we left yesterday. And we'll see. We have a feed, so let me get you over here. Thank you to Topmark Media and Scott, Recovery Addict, always bringing us this feed. So we're really, really grateful and thankful for that. So let me just get us over here. And we have a new poll for you guys. And also, we hit 18,900. We just hit 18,000 last Thursday. We're at 18,900. So we made 900 subs in a week. Good job, guys. Good job. Thank you so much. And again, thank you to Scott, Topmark Media, Recovery Addict, for presenting this stream to us. So awesome. All right, hold on a sec. Hold on. All right. How's everybody doing? Running with Scissors, Red Snap. Welcome in, Kimbers, Alice. Good morning to you. Wizard of Ezzy, good to see you. Hell Rider, welcome in, Jane Dixon. Hey, Mike, and Richard, I saw both of your emails. I didn't know we had two Richards in our chat, so didn't realize that yesterday, Richard. And Mike, yeah, that guitar is pretty cool. Let me show everybody this guitar. It's pretty cool, but I feel sorry for the guitar. So Mike sent this to us, you guys. Here, check this out. It's pretty. Wait, hold on. It is pretty cool. I have to admit, it is cool. But then I'm like, oh, that poor guitar. This reminds me of like an MC5 guitar or something. This is something Fred Sonic Smith would play. Here, check this out. This is pretty cool, Mike. I do like it. I'm just sorry that this guitar ended up as a table, but that is pretty wicked. That's pretty cool. Yeah, that's totally like a MC5. Who's the... Oh, it's even signed. Oh, is that the person... Somebody signed it. I can't see. I can't tell the... But that's pretty cool. So that's pretty cool. Thanks, Mike, for sending that. Yeah, Butchered is more like it. Squid Kid, good morning. Tracy, good morning to you. Nana, Shirley, good to see you guys. Thank you for joining us. Kimbers and Jenny G, Green-Eyed Cat, Ed. State did not rest. We still have to get through cross of O'Driscoll. Ionine, good morning to you. Sharon, it's cool, but it's also like, oh, yeah, butchered a guitar. It's like cutting off your arm. M. Murgatroyd, good to see you. Radioactive, good to see you. Your fiance would love that guitar table. Does your fiance play guitar? Did I know that? If I didn't know that, how did I not know that, Kimbers? Oh, wait a minute. Yes, that's right. I did know that. He's in a band. Sorry. I retract that statement. Sorry. I knew that. Jaded Wonder, good to see you. JMS, welcome in. Little Lulu, good to see you. Barry, I really hope Bloodworth cleans it up on redirect and ties it together. I wasn't with Trina K until her final witness, so maybe it's a four corners state prosecution method to do it that way. Wizard of Ezzy's thanking Scott and Recovery Addict for providing this stream for us. Yes, absolutely. Jane, it was 84 yesterday. Today it's 42. We broke a record. I think it was like 91 or 90 or something. It was warm. And then I think we're going to be in a high of, we're going to get into the 30s next week. Just crazy. Crazy. Jaded Wonder, I love that. I love that table. It looks awesome. It does look cool. I will admit it does look cool. I'm not gonna deny it does look cool. You know, that does look cool. But I just feel bad for the guitar because I'd want to play that guitar. I want to play that guitar. Raj, good to see you. Amy, some crazy weather in Georgia. Terry Trial Watcher, good morning to you. Misty Bates, good to see you. I think I saw Miss Bree as well. Miss Bree, welcome in. Golden Dog Lover, welcome in. Hola, hello. Tracy Tinker. It was surprising the cop was so vague. Seagate. He's the bass player. Yes, Kimbers, I knew that. Sorry, I didn't know that. I would be horrified, Mike. I would be horrified. Let's see. Brat, good to see you. Yep, Mother's been sitting in the courtroom, so she won't be able to testify. So you could throw her out. I realized that after we set that poll, so we could throw her out because she's been watching. So she should not be allowed. Only like law enforcement, like lead detectives, they're allowed to testify. Hey, Joanne, good to see you. Yeah, that's why I'm saying it's so MC5. If you guys know who MC5 is, they're totally their vibe. Hellrider, you're a drummer. Let's get a band. Yeah, let's get the band. Let's get the band back together. Kouri's mom was allowed to sit in the courtroom. So that means she's probably not going to, well, she can't testify if she's sitting in the courtroom then. Linda, good morning, lurking as usual. JMS, you don't think the brother, there's two brothers. There's DJ and there's Ronnie. So you don't think they're going to. There you go, Just a Girl Baking. Yep. That's exactly it. All right, so let's just recap briefly what happened yesterday. We had the two parties got together after a big kerfuffle the night before, the day before. Apparently they got together over the evening. They sorted out what was going to come in with Detective O'Driscoll as far as the interview with Carmen, and they sorted all that out. Carmen did come back to testify for all of like 10 questions, if that, so maybe 10 minutes, 10, 15 minutes. And then O'Driscoll came back on. And he was a little, his testimony was just, I don't want to be mean, but it wasn't what I was expecting. Let me put it that way. It was not what I was expecting. I was expecting O'Driscoll to be yes, no, instead of I don't know, or I wasn't a part of that, or don't know, don't recall. So I was very, very just disappointed. I guess that's the best I can say it. So I don't think it's going to change to today. I think it's going to be more of the same, where I don't recall, I don't know, I wasn't a part of that. That wasn't, And then again, being the lead detective, we've seen other trials where the lead detective is like spot on, just boom, 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 spotting those raccoons going down the Garden State Parkway. And we'll see. We'll see what happens today. I'm sure Mr. Bloodworth will clean it up. Not that it needs cleaning up. Maybe some people think it doesn't need to be cleaned up. I don't know. What do you guys think? Do you think O'Driscoll was solid, or do you think he could have been better? What do you guys think? Oh, and here comes the good judge. Judge Mrazek coming on in. Iowa Backyard Cam, good to see you. Kelsey, I said earlier I had no doubt till watching Lead Detective and Carmen. Now I'm not totally convinced. Yeah. Red Snap, you were disappointed. Kathy, good morning to you. Looks like it's raining where you are. Amy, good morning. He was not a good witness for the state. Let me turn this down a little bit. Recross better clean it up, Jane says. Nan, good to see you. Thank you for joining us. Hey, Mona, I thought the defense won points with their cross. O'Driscoll was a bit snarky at times too, Wizard says. Barry says, bro just came to drop off the orange notebook and walk the dog. Just a Girl Baking, I didn't like the wishy-washiness of his testimony. Betsy loves hippos, so. Linda, maybe he studied overnight. Heidi, yes, he needs to clean up. Dream Horse, detective testimony didn't bother me, just confusing questions from defense. Amanda, I thought he let the prosecution down. Sharon, could have done better, but I think motive means opportunity. I'm not, Crazy Mary Jo thinks he was fine. JMS, I think he was fine, and along with all the other evidence, the prosecution has built a solid case. I'm still not past my thoughts. I still think the state has done a good job in building a case. I'm okay with that. Hey Mona, O'Driscoll should have actually had answers. Green-eyed Cat, good morning. Sod Girl, good to see you. Jane, we as 13th jurors are spoiled by other lead detectives. Yeah, then there's that. Jenny, I hope the detective did a bit of studying last night, but I think she's still guilty. That's that's where I am too. That's where I am too. I think that, well, let's see what the defense brings in, because right now, I think the state has met their burden. I think they've proven it. It's all circumstantial. I get that. There's no direct evidence. We've seen many, many cases that are circumstantial and people still are found guilty. So again, means, motive, opportunity for sure. I just wish the lead detective wouldn't have had as many I don't knows, I don't recall, I wasn't there, that wasn't part of my... It's almost like he's saying it wasn't my job. You know, he's like, every other people were doing this. And again, as a project manager, you know, I've been... I want to know everything that my team is doing, you know? I want to know everything my team is doing. YT Hazel, good to see you. Jane, I'm still at guilty, though, as there's lots of evidence that we have heard in past weeks that we will hear in closing. Wizard of Ezzy, O'Driscoll does need a touch of rehabilitation. Yeah. Yeah, for sure. Right, we see Judge's head. We see Judge Mrazek's head there. Hey, Kathleen, good morning to you. Gina, good to see you. YT Hazel, hello, hello. I see you waving. Sharon, guess you should have known digital for day before. Richard, I met with all my detectives every morning to get updates on where they were at in their investigations. Iowa Backyard, I can see prosecutors asking in recross, if you had your notes, could you have answered? That's true. He did say a lot, I need my notes. He did say that a lot. It's not in front of me. I need to have my memory refreshed. He did say that. He did say that. Janet, I'm feeling like you. Let's see. Hey, Mona, this case will need a very good prosecution closing statement. Brett says, I certainly wish O'Driscoll had been more compelling, but I'm comfortable with the evidence, whether or not the lead detective still has it all in mind. Yeah, I think that's where I fall as well. Kelsey, why didn't he have his notes? Well, there was a lot of like, there was a lot of, that was somebody else's responsibility. I came in at this point in the investigation, which is fine. I mean, he did come in later, but there were just some basic things that he didn't get, or he didn't remember, or they didn't do. I guess maybe it's, I don't know. I just heard a lot of I don't knows, I don't recall. That wasn't my, almost it's like that wasn't my responsibility. That was somebody else's responsibility. So it just opens the door to, you know, investigators not doing a complete job, you know. That's all. And I had no problem with Carmen and, you know, the blueprint. I didn't think they were leading her. I didn't think, you know, your get out of jail free card. I think they were like, hey, you know, you're having trouble remembering stuff. We get it. Take your time, you know. And I thought, you know, it's not like, I don't think Carmen was just making stuff up, because her digital footprint matched what she was saying, you know. So I think that's why I can get behind what Carmen was saying as truth. You know, I don't think Carmen was lying.
Yes.
We're on the record in 231-500-139, State of Utah versus Kouri Richins. Counsel for the state and the defense are present. Ms. Richins is present. May we begin by confirming whether or not there's any legal discussion we need to have regarding the text message excerpt that the defense offered during cross-examination of Detective O'Driscoll at the end of the day yesterday.
Yes. Yes, Your Honor, I think we do. May I stay seated so I can read my...
Of course.
Okay. Just 1 second. Let me pull it up.
If we can all look at it at the same time, I'd appreciate it, Katie.
Are you pulling up the Celebrate one or the... Okay. So it's up on the screen right now. So it starts with Bates number state, STATE, 0335281. And this was produced to us before the state went through and updated the time. So this is on UTC time instead of mountain time.
Okay.
At some point in this case, and there have been so many supplemental, I think we're on our 10th exhibit list. I think we're, anyway, hundreds and hundreds and hundreds and hundreds of alterations and substitutions. But this is the one we got before they had changed the UTC time, which was confusing to everybody. And so they went back and redid that. This version, they had not changed it yet to mountain time. This is a consecutively numbered, Bates numbered document. There's no pages missing. This is coming from a Celebrite extraction of Eric's phone that was seized by Mr. O'Driscoll. We just found the Celebrite and extracted by Miss Gibson.
Can you show me the Celebrite
Yes,
version
sir.
of this?
We can, and we're pulling it up right now.
It's a very big file, so what I've done is I've emailed Katie the cover page, and then I'm working on the box download so she can download it. Right.
Forgive me. And this is a nuts and bolts question.
Sure.
Forgive my ignorance. I'm looking at one page that shows 3 text messages total.
Right.
Typically, these are a complete string that has a Celebrite header. Where is that version of this text?
So not all of the ones we've introduced in this trial have the Celebrite header. Only some of them, not all
I
of
don't
them.
know if is that true. I thought
That's
all of them had the Celebrite header.
No, that is not true.
Hold on, let's pause there for a second, because I think that's how we've been laying foundation for the admission of them so far. Foundation.
Right.
Mr. Bloodworth, is my memory correct? Unless they came from, we've had CDR-related metadata regarding text messages. We've had some non-bubble related or non-bubble depicted cell messages that have come out of other extractions. But in terms of blue and green bubbles, I thought all of them had a Celebrite header.
Yeah, I believe that's right, Your Honor. If we prepared an exhibit that comes from a Celebrite extraction, it has the Celebrite header.
Right.
There's others where we just, we've got texts from other means. Somebody sent us, forwarded us text, right?
Right.
But if
Screenshots, for example.
correct.
Yeah.
If it comes from a Celebrite extraction, as best I recall, it has the Celebrite header.
Okay. And Ms. Nestor, I'll give you the record back here in a second, but it's also unclear to me, is this 3 text messages that we're talking about, are they part of a larger exchange that has already been admitted?
So these are all the text messages he had with Kouri on the day he passed, on the 3rd.
On the 3rd or the 4th?
He died early morning in the 4th, so it's from the 3rd.
Okay. These 3 bubbles are the sum total of their text traffic on the 3rd?
No, we have more than 3. There's, just a minute, there's a couple pages to it. It's the last set of texts that they, there's multiple, see, that's the 2nd page. And, yeah. And that's the last text that they had between the two of them before.
Can you go to that one, please? Katie, can you blow up the 3rd one on that sheet? So, As I understand it, among other objections that the state may have, the first one is foundation, correct, Mr. Bloodworth?
Yes, so that's the threshold objection.
Right. And as I understood it yesterday, the foundation objection was this is not what it purports to be because the daytime information is inaccurate.
Well,
Correct.
Your Honor, the state's question as to whether this is what it purports to be, the genesis of that is that I noticed that the time is not corrected, and I would expect for the Celebrate downloads that we have authenticated and laid foundation for, the time change is baked in.
Consistent across the board.
Right. So the fact that this is still in UTC -5 instead of UTC -6 or 7 just caused me to question where this came from, which Celebrate download it came from, and I still don't know.
So that brings us to, is there a version of this that has the Celebrate header?
that's what's on the screen right now.
And so if you would scroll through this extraction report and show me where it includes the portions that you want to use with this witness, just so we're all on the same page.
Just give us a second.
No problem.
It's very long, so we have to go right to it. Just give us just 1 minute.
No problem.
Yeah, we're going to have an issue with that.
Oh, are you on a Mac? Oh, God. Our millennial has a Mac, so it may take a second.
Well, this discussion doesn't need to be had with me on the record in front of everybody. If you can have it with each other first and then distill down what the dispute is, if any, regarding the foundation.
Yeah.
I understand there may be other objections that we have to get into.
And perhaps, Your Honor, we could work parallel while they're seeking out the foundation information. We could address a couple things. I think it's hearsay, as best I can tell. These are conversations between the defendant and Eric Richins. The state's further objection is that it's beyond the scope of the direct.
Let's handle those one at a time.
Okay.
Ms. Nestor, regarding hearsay, your client's statements are hearsay if they're offered by you.
Right.
Eric Richins' statements are categorically hearsay if they're offered for the truth.
Right.
What is the non-hearsay purpose of these particular text messages?
So we are actually not interested at all in what is being said, and we could do an instruction to that, to that effect. What we are trying to get in with this exhibit is a photograph that was sent on the day before. Technically, Eric died on the 3rd. And that was sent the day before. That is connected to the GIFs, whatever you say, that all got accessed the next morning at 8:30, which the state is making a big deal out of and mentioned in their opening and has called witnesses about it.
Provide a little more context. What is the photograph of and who is it sent by?
The photograph is sent by Eric to Kouri on the 3rd from when and there's been testimony that's come in that he was out there spreading gravel to make it look nice for the closing or whatever. And he sends her a picture of it while he's there, before he gets home that night. That is one of the pictures that is connected to the GIFs that were accessed, the orphan GIFs, the next morning at 8:40 as soon as the police leave, and they're trying to make it seem like Kouri was celebrating he died with these happy GIFs. And it's connected because that picture was the implication that's being made is that those GIFs were being sent or accessed or sent by or to Kouri the morning Eric died, when actually the picture that was also accessed at the exact same time came from the day before. So it doesn't mean that. And that's what we're trying to explain to the jury. All I care about is the non-testimonial section of the interaction that shows he sent a picture on the 3rd, and that's one of these pictures that was accessed with these GIFs at the exact same time, and it was sent the day before. And that's all we're trying to do. We don't care about what's in the bubbles. We can black out what's in the bubbles. I don't care.
Why are you doing this through Detective O'Driscoll? Why didn't you do it through Mr. Kotradimos? I'm not sure Mr. O'Driscoll or Detective O'Driscoll has the ability to testify to any of what you just said.
Well, he testified that he reviewed Eric's communications the day before he died. He did testify to that.
Right, but this goes well beyond that and is far more technical.
All I'm asking him to do is say, did you see he sent her a picture the day before? The rest of it we'll do separately.
But that's not necessary foundation for the argument that you're trying to make. This is a technical metadata-based argument that I understand why defendant believes it's relevant, and I'm not suggesting it's not. I'm just not sure it's this witness.
I'm not going to ask him about any of the metadata. I'm going to say, did you look at Eric's phone the day before? Did he send this picture to Kouri? That's all I'm asking. Nothing fancy, nothing technical. He said he reviewed Eric's phone, that he looked at his communications. And we can even take out the metadata and just show the picture. That's all I care about.
Without the metadata, the picture is not relevant.
Well,
you need the date and time.
We have that. No. We do need the date and time, but I'm talking about the. I thought there was more information on the bottom of those things. And
Why are we doing this through Detective O'Driscoll rather than through another witness that can testify regarding the relationship between the file path for the GIFs and the file path for this photograph?
Because he reviewed it and saw it. I mean, I think he can testify to it.
Alex laid the
You can't testify to any of the technical relationship that you're asking for.
Correct, and we're not asking for that. That's all we're asking him is to say that the picture was sent the 3rd. That's all I need him to say, and he knows that because he reviewed it, so he's capable.
He knows what he saw. How does he know that the picture was sent the day before?
Because it's on the face of it.
But then it's coming in for the truth, right? And so,
but that's not testimonial evidence.
I agree. So if it's not testimonial and it's on the face of the text message, what difference does it make that Jeff O'Driscoll reviewed it? I'm not suggesting you can't get the evidence in. I just don't understand why it's coming in through this witness.
This is the witness we would like to bring it in through.
I don't know that this witness has foundation to give you the testimony you're asking for. What's the question you're going to ask?
I already asked him. I said, did you review Eric Richins' communications the day that he died? And he said yes.
Okay, and then what's the next question you're going to ask?
Is this picture, was it involved in what he sent the day he died? That's all I'm asking.
You just want a yes or a no?
Yeah. I'm not asking him for any
I'm not
technical.
sure that's even a dispute. Go ahead, Mr. Bloodworth.
Let's never come out before on any other witness.
Okay, but go ahead, Mr. Bloodworth.
I didn't have anything, Your Honor.
Okay. Is there any objection to him just saying yes or no to that question?
Yes or no to the question of did he review Eric Richins' text messages from the...
I think that's already been answered, yes or no.
Yes. Yeah. Then what's the follow-up?
Did Eric Richins send a picture as part of those text messages?
And so if
Detective O'Driscoll says, based on my review, he did, period.
I still don't know if that is sufficient foundation to admit this.
Well, I'm not sure it's going to be admitted. I just think they're trying to lay foundation, I guess. Did you want to publish the photograph, Ms. Nestor?
I do want to publish the photograph.
And tell me why the photograph is relevant?
Well, that photograph is already in as part of Exhibit 340, which
it's not in, but we've stipulated.
We've stipulated is coming in next. But I just want to show it's the same picture. That's it.
And forgive me, you're referring to an exhibit that hasn't yet come in?
We've stipulated to it. It's about to come in.
Through?
O'Driscoll.
And what is 340?
It's the list of all the pictures that were accessed that morning at 8:35 a.m.
What?
Why don't we just do it in the reverse order then?
I can do that.
I mean, we can see, Your Honor, I still think there's a hearsay problem. Based on counsel's explanation now, I also think there's a relevancy objection. The photo that we've been discussing,
The gravel photo?
the gravel photo, was not accessed at 8:39. It was accessed at 10:42.
Well, this is a foundation question, but the premise of the question Ms. Nestor is seeking to ask is, was this photo among the communications or sent by Eric Richins to Kouri Richins on March 3rd, right?
Yes, sir.
Full stop. I don't think that's fairly in dispute, right? And I don't think that's a hearsay issue.
I think publication's the hearsay. The fact that any photo was sent is fine. I think if we get into the specific photo that was sent, there's a hearsay problem.
Are you taking the position that the photo is a statement?
Yes.
I'm not sure that follows without additional context. Just sending the photo it's evidence, it's a fact. I'm not sure it's a statement.
The statement is, I just dropped gravel at the Midway Mansion.
Well, I don't think any of that's coming in. It's just the photograph.
But that's what the photograph says.
I don't understand. Is there text on the photograph?
No, Your Honor, but the defense has, as part of their case, said that Eric Richins was into the Midway Mansion as evidenced by him dropping gravel.
I want to come back to what I understand is being proposed by Ms. Nestor through this witness. Detective O'Driscoll, did you review Eric Richins' text messages with Kouri Richins the day before he died, yes or no? I understand the answer to be yes. Did he send Kouri Richins a photograph as part of those text messages on March 3rd, yes or no? Yes. Is this the photograph that he sent? Full stop.
I'm fine with that. The only, I think there's a third option. It's not yes or no. It's I don't recall.
Oh no, fair enough. I'm not telling him how to testify, and I don't know what he'll say. But as long as you don't go beyond that, Ms. Nestor, and as long as you don't make any representations regarding time, date is fine.
Great.
Then we don't have a foundation problem. We don't have a statement that would be subject to the hearsay rule. I think the low bar regarding relevance is met in as much as the defense seems to be laying foundation or an argument to come later regarding when images and file paths on Ms. Richins' phone were accessed. Any other nuances here, Ms. Nestor?
I don't think so.
Do you understand? Do we have a common understanding of the limits of what you can ask Detective O'Driscoll without drawing another objection?
Absolutely.
Do you have an image of just the photograph?
I do, but I think if it's out of context, he won't. It's too hard for him to. I mean, I think it needs.
You can't show the text messages without provoking the hearsay problem.
No, not to the jury, just to refresh.
Oh,
because I think it's got to be. He's not going to know. It's just going to be a weird picture.
Understood.
Should we just go ahead?
Are you going to publish the photo to the jury, though?
No.
Oh, okay.
So, we could just go ahead and admit 340 now, because then the next question is going to be: is this the same photo that is in this picture right here? And then we're done. Is this the same photo?
This is not a question for me. It's a question for Mr. Bloodworth.
No objection to admitting 340.
Okay.
I don't know that. Now, there's the follow-on. Is this the same photo? That is akin to publishing the photo that brings up the hearsay problem.
You've made a record regarding the state's position that the photograph by itself is a statement subject to the hearsay rule. I'm not persuaded.
Okay.
And so, however, I don't know that just admitting 340 without providing the jury any testimony to provide foundation for context is going to be helpful.
I'll do
so
it.
is somebody going to tell them what 340 is?
I'll do it through him. I'll just do it through him.
Okay.
That's fine. We do have one other issue. If we're resolved with this, I think we're all clear. I know what I can ask and what I can't. I think we're fine.
Okay.
There's another issue. May I bring it up?
Please.
All right. I really need Officer O'Driscoll to leave the courtroom when we talk about this because it's
Oh.
about specific questions.
No problem. Detective, if you'd take a step into the lobby, please don't talk to anybody while you're out there, sir. Thank you.
Okay. Thank you, Your Honor. I'm doing this out of an abundance of caution to avoid any potential. I'm trying to be very careful to comply with the court's ruling on the motion in limine not the motion in limine. The motion to admit the statements of David Norris.
Not.
Correct.
Yeah.
Our motion to admit that was denied.
Yes.
So just to make the record, the defense sought in advance to get approval we gave notice to the state that we intended to call a witness named Mr. Norris, who would testify if called, that on an occasion in 2019, I believe, in 2019, he had an encounter with Eric Richins where Eric Richins asked him if he had any fentanyl. He had corroboration for the interaction, not the statement, but the interaction with Mr. Richins, specifically the check that Mr. Richins had given him, the date it had cleared his checking account, and the invoice for the work he had done for him.
Or for Kouri, but...
Correct. The court the reason we were trying to introduce that statement, we were trying to get it through the catch-all exception to hearsay.
The residual.
I'm sorry, I call it catch-all. Same thing. The residual exception to the hearsay rule, which requires a head notice, which we did give. The state objected to that coming in. The court ruled upon it, did the analysis under the residual exception, and made a finding that the defense could not call Mr. Norris to the stand to testify because the residual hearsay exception requirements were not met. It is my desire with this witness to ask him the following 4 questions about his investigation. And it touches on Mr. Norris's testimony, but it's a separate matter. But I just, out of abundance of caution, I am giving you a heads up. So the first question is this. You discussed with Mr. Bloodworth yesterday that the way you approached this investigation was to look for evidence based on 3 possible scenarios: an accidental overdose, a suicide, or a murder, correct? Question number 2. And in order to properly investigate whether there was an accidental overdose, certainly any allegations that Eric had a prior history of seeking fentanyl would be potentially relevant and important to look into, correct?
Pause there for 1 second. I got to write.
I'm sorry. I do have these if you want me to email them to you.
No, it's okay. Just give me a moment.
No worries.
Was it prior allegations that Eric...
Any allegations that Eric had a prior history of seeking fentanyl would be potentially relevant and important to look into, correct?
Got it.
And this is the next question. Within the past few months, did your team of investigators become aware that there was an individual contacting the Summit County Sheriff's Department who wanted to share with the investigative team information about about an incident where Eric allegedly asked someone for fentanyl? Want me to read that again?
Sure.
And within the past few months, did your team of investigators become aware that there was an individual contacting the Summit County Sheriff's Department who wanted to share with the investigative team information about an incident where Eric allegedly asked someone for fentanyl. And then there's one more question. Let me know when you're ready, Your Honor.
Share investigative team. Give me the last clause one more time.
Who wanted to share with the investigative team information about an incident where Eric allegedly asked someone for fentanyl.
Okay.
And the final question is, did you or anyone else connected to the investigative team ever sit down with this individual and talk to them? Did you make any efforts to see if this individual was credible or had corroborating evidence to back up their claims? And that's it.
Mr. Blood.
No objection to the first question. Objections to the next three. This is a transparent attempt to circumvent the court's 807 ruling regarding Mr. Norris by casting some sort of inference that what Mr. Norris would have testified to is admissible. This setup has been long in the making. After the court issued its 807 ruling, Mr. Norris called the Summit County Sheriff's Office. Deputies interviewed him, and he said he was calling on behalf of, he was calling because defense counsel told him he should call.
Maybe we just pause here for a moment. I don't know that we need to go into any of that. I understand part of your objection to be a lack of foundation.
That is the beginning, Your Honor.
I think that's the beginning and the end of the discussion. There's no foundation for the premise of your questions 2, 3, and 4.
I'm sorry, but I don't understand. We have been produced a report from the Summit County Sheriff's Department confirming this call was made and confirming that there was no interview of this individual. It goes not to the credibility of the individual, it goes to the credibility of the investigation that they chose never to even speak to him.
There is no foundation for the premise of your question. It's as if you could make up any set of facts and put them in the question. If there's no foundation, it can't be the premise of the question.
I'm sorry, but I don't understand what you mean by there's no there is validation from the state that this call happened.
It's not that did you interview a person named David Norris. It's the substance that is the premise of the question. There is no foundation for the premise that Eric had a prior history of seeking fentanyl.
But that's not the way the question is worded. The question is worded is someone contacting you, asking to give you information about it, and you refuse to interview them.
That's not the question you asked. Read the whole question.
In order to properly investigate...
No. Go to number 2.
That is number 2.
My apologies.
And in order to properly investigate whether there was an accidental overdose, certainly any allegations, not facts, not nothing, just an allegation, that Eric had a prior history of seeking fentanyl would be potentially relevant and important to look into, correct?
Let me ask it this way. What would your response be if Mr. Bloodworth got up and said, certainly, detective, you investigated whether Hayden Jeffs had done all the stuff that I've excluded in my ruling regarding Hayden Jeffs? Would you be like, no problem, you can say that?
That's a fair question.
It would be reversible error for me to allow that question. There were 2 residual exception rulings in this case. Let's be fair about it.
Right. That's absolutely correct. So is there a way, if we scrub out the reference to fentanyl and we don't get into the specifics of exactly what was said, because I understand their concern about that and the court's concern, which is why we raised this in advance, which is why I'm trying to do the right thing here.
I appreciate it.
If we just said that an individual contacted them with information about an interaction with Eric involving drugs, illicit street drugs, and they chose not to investigate it at all, it does go to they've set forth this hypothesis that, well, we eliminated all other possibilities. And that's just not true. They didn't eliminate all other possibilities because they chose not to interview at least one person that clearly would have supported the first hypothesis, that he ingested it intentionally. So that's all I'm trying to get in. I am trying to get that in.
You may be trying to get a little bit more in.
Well, as much as I can possibly get in.
Fair enough.
But I do think it's fair game to say, look, you've got someone coming to your office saying he tried to buy drugs from me, and I want to be interviewed, and they are like, no, thank you. I think I'm entitled to get that in, and I'm willing to do it in the most ethical, careful, reliable, non-inferential way possible, but I do believe that's fair game. And I'm open to suggestions, whatever I need to do.
These 4 questions are not it, Mr. Bloodworth. You look like you're about to say something. I'm sorry.
No, Your Honor, as I understand, the status quo is the court's, I guess this court has sustained the state's objection to those questions.
I have. I think what Ms. Nestor is trying to ward off is another set of objectionable questions that are maybe more general, less specific, some version of probing the bounds of the state's investigation of the charges. Yep.
Your Honor, no. It's the same foundational objection, right? This is all to suggest that there is admissible evidence that Eric Richins sought fentanyl before. And at bottom, there is no admissible evidence that he sought fentanyl before. And I don't think that there is any good faith basis to suggest otherwise, or to suggest that any investigation into it was incomplete. Because the fact is, detectives, that Mr. Norris's narrative has been so thoroughly dispatched that there's no good faith basis to allude to an improper investigation, much less that there may be admissible evidence.
May I respond?
Yeah, hear me out for a second.
Sure.
Or let me make sure I understand the bounds of the argument here. You said there's no admissible evidence that Eric Richins sought fentanyl. My sense of the evidentiary record so far, and the evidentiary record, or the universe of admissible evidence that's available, is that there's no admissible evidence that Eric Richins ever sought or received narcotics except through a prescriber. Correct?
Correct. The only admissible evidence that's already admitted,
I think it's his knee surgery,
is
right?
a 2016 hydrocodone prescription following knee surgery.
Right, okay. Very good. Now, by the same token, I believe all the admissible evidence of Ms. Richins seeking or receiving narcotics of any kind is already in. Correct? And all is putting it strongly, but yeah, that is, to the extent there was any admissible evidence of Ms. Richins seeking fentanyl, it's either in or it's not admissible. Let me say it that way.
Or it would come in a rebuttal case.
Understood. Okay. Which was the basis, among other things, of not the basis, but is related to the court's exclusion of the offered statements of Hayden Jeffs to his sister.
Right. Right. So I do wish to correct Mr. Bloodworth's statement that we have fully dispatched Mr. Norris's proposed testimony. To the contrary, the court was very clear that you were accepting, for purposes of your analysis, that everything in the affidavit that Mr. Norris provided was true, and that you did the analysis, the court did the analysis based on the law of the hoops you have to jump through to come under the residual exception. And for purposes of your analysis, you did not go into an analysis of whether Mr. Norris's testimony was credible, not credible. You just said, I'm going to assume for purposes of this ruling that everything in that affidavit is true, and then I'm going to rule on whether it fits the residual exception. And the court went through a very thorough analysis and decided it did not. So I don't think that's a fair statement that he just made, that we fully dispatched it like there's nothing behind it. That's never been litigated in front of this court, nor have we asked it to be.
The difficulty here, though, is imagine David Norris were on the stand.
Right.
And you asked him, hey, did you ever contact the Summit County Attorney's Office, or Sheriff's Office? My apologies.
Yeah.
He says yes. And then you say, what did you tell them? It immediately provokes a hearsay objection that I've already dealt with under my ruling on the residual exception.
Absolutely. And we don't.
If you want to elicit testimony that, did you ever speak to a gentleman named David Norris? Yes. And then move on, fine, but I'm not sure how that's relevant.
Well, that's meaningless to a jury unless I can say, was there a gentleman named David Norris who tried to give information that would have supported the first hypothesis?
But that's the hearsay problem.
But it's not being offered for the truth.
It's
being
100%
offered,
being offered
Your
for the
Honor,
truth.
if I may please, it's being offered for the same reason they've gotten in a ton of other hearsay in this case, by the impact it has on how they did their investigation. They got that in through Woody. That's how they got in Amy and Katie's statements, because it wasn't for the truth of the matter that Kouri tried to kill him before. It was how it impacted her investigation from there on out. This is the same exact argument. It's how the fact that they got that information and chose not to even investigate it, how that impacted the hearer. It is irrelevant for purposes of the truth, and the court can instruct it like you've done over and over and over for their witnesses when we had this exact same argument.
If that's true, Ms. Nestor,
Yes.
then the 807 residual exception wouldn't exist and it wouldn't apply. It does apply, and so you can't use this argument to undermine that.
I know, that's why I'm trying not to undermine your ruling.
That's why the substance of what he told the Summit County Sheriff's Office can't come in.
And I think I could maybe craft a question where we leave out the juicy substance and just say there was an avenue that you chose not to investigate. But I've got to get something in context so the jury understands, hey, you had this road, you chose not to go down it. That was your choice.
I appreciate why you want to present this to the jury, but there are limits on both sides of the V about what gets presented to the jury. And those limits are in part defined by the Utah Rules of Evidence. And this substance cannot come in under the Utah Rules of Evidence. For the same reason that the state could not argue that we want to get in Hayden Jeff's statements to its sister just for the effect upon law enforcement in terms of the scope of their investigation. No.
Okay. And there's no scenario which we're going to be allowed to question him about choosing not to investigate this evidence.
There's no scenario in which it's relevant without the substance of the excluded communications. If a crank from New Jersey, I don't know why I'm picking on New Jersey, but I grew up near New Jersey, called the Summit County Sheriff's Office and said, I was in Utah on that day and I saw it happen, and the Summit County Sheriff's Office chose not to investigate it, would we be having this conversation?
That's not this circumstance, though.
It is the same, though, because that evidence has nothing to do. Here it's even worse because it's inadmissible.
It's inadmissible from Mr. Norris's mouth, but I don't think it's inadmissible, period, in terms of if it was part of an investigation that was ignored or not followed.
The substance isn't admissible. The fact that they spoke to David Norris as a fact is admissible if it's relevant. But without the substance, it's not relevant.
We have just a moment.
Sure.
Okay, Your Honor, I think we've made our record on that, and I'll, of course, respect the court's ruling on that.
Let me take a minute. Let me just take 5 minutes.
Thank you, Your Honor.
Before I take a break, Mr. Bloodworth, anything further on this issue?
No, Your Honor.
Ms. Nestor, before we take a 5-minute break, any other issues before we invite the jury?
No, thank you, Your Honor.
Mr. Bloodworth?
No, sir.
Okay, I'll be right back. Thank you. All right.
So did the judge see something now that he's going to reverse his ruling? Oh, man. All right, so of course, this trial is just nothing but mud. All right, this trial is nothing but mud. So the judge asks, are there any legal discussions that you want to talk about? And the defense says yes. I don't even know where to start. Okay, it was just on the text messages. So at first it started with the defense was concerned about UTC time versus mountain time. All you have to do is just take UTC and subtract whatever, 7-8 hours, depending on daylight savings time, whatever it is, right? So they were going on about a photograph that Eric sent to Kouri the day before, so March 3rd, of him spreading gravel at the Midway Mansion house. And that did come in before. That came in through the forensic accountant, of all people. Of all people, it came in through her. Let me just see if I can find that again. Eric was spreading gravel the day he passed away. This was on cross, and this came in from the forensic accountant, Brooke Carrington. So she brought that in. She's the one on cross. She's the one that said that she knew Eric was spreading gravel the day before. Once she read the email showing, so I'm kind of reading around, I don't know how she knew that. Maybe because she's doing forensic accounting. She's doing accounting, right? I don't know how she knew that Eric was, well, she must have seen a picture. Clearly she saw a picture. So anyway, so that did come in through a previous witness. So now the defense is arguing that this gravel shows the photo shows Eric dropping gravel at the mansion, and they want to bring it in. They want to bring it in because they asked Driscoll, she doesn't want to ask anything technical or fancy. She just wants to show O'Driscoll the photo. And judge is saying, well, why didn't you ask Cotrodemus this? This is a technical question. And she's saying, no, I don't care about the metadata. I don't even care about the date and time. I just want to get in. Eric was spreading gravel at the house before he passed away. So, and it's basically, did you review Eric's phone? So it's all about, again, it goes to investigations and did they do a proper investigation? Did law enforcement do a proper investigation? So that's what Miss Nestor, keeps on hammering here. Then she asks, okay, so they determined that she's just going to ask very specifically, did you know that Eric was spreading gravel? She's not going to ask anything about date and time and all that stuff. So they agree that she can ask at least, did Eric send this photo? Yes, full stop. So that's it. So that's as far as they're going to go. They're not going to get in, when was it sent? What's it say? So she's agreed to that. Then she has this other issue, which she's asked O'Driscoll to leave, and it's about this David Norris. So it was a motion to admit statements of David Norris, and that was denied by Judge Mrazek. So apparently in 2019, he had an encounter with Eric in 2019 about Eric asking for fent, right? And so he apparently calls law enforcement. Now the state comes back and says he was basically vetted. Yes, we know about this. We contacted him. We interviewed him. We vetted him. It's irrelevant, or just there was no foundation. There's no substance. Just didn't go anywhere. So again, defense is trying to constantly attack law enforcement investigation, which I get it. That's what they do, right? That's what defense does in almost every case, if not every case. So then ultimately, the judge says, no, this is all hearsay, and he even brought in New Jersey. And he's like, I don't know, I don't mean to pick on New Jersey, but he says he's from that area or around there. So he's like, what if some crank from New Jersey calls and says, hey, I got some information? We wouldn't be having this conversation. So they're ready. It seemed like they were ready to call it a day there and get on to testimony, but then he looked at his computer or he looked at something, and now he needs to take 5 minutes. So I don't know what he saw that made him change his mind, but he wants to make an abundance of caution, as they always say, and in an abundance of caution, he wants to make sure all the T's are crossed and the I's are dotted. Sharon, why can't defense bring on a witness to back up her statements this morning? Because it was ruled upon. It was ruled upon that they can't bring in this David Norris. So they can't bring him in because it was already ruled upon. Carla, good morning to you. Your problem with the defense is that they're always trying to put things out of context. One picture doesn't mean he went inside the house. Elaine, I think I have missed this somewhere, but if Kouri is found guilty, what sentence is she looking at? That should be, is that in our description? It should be in our description. Aggravated carries 25 years to life without parole. The additional felony charges could result in further prison time and significant financial penalties. So she's 25 to life or life without parole. So far, that's what we have. So if you guys have questions, check our description first. But we have charges and then if convicted. So right now, 25 years to life or life in prison without parole. So that's what she's looking at. Nan, I think and hope it's just so he can write out his answer. We'll see. Sharon, so what is the problem? I don't know. He saw something. He was looking, right? He was looking at his computer, or he was looking at something. Maybe he was looking at his ruling. There was something he was looking at. I don't know. Hey, Amber, they technically they should have already started, but defense had a couple issues, so we've brought that up. Sherry, good morning to you. Tammy, good morning. Welcome in. Let's see. Becca, so they're trying to claim that Eric was a casual event user. Isn't that highly addictive? Went his life and shown some consequences. That's what I'm thinking. That's what I'm thinking as well. But defense is trying. Judge Mrazek was, Barry. Judge Mrazek looked. Let me go back. He looked at something. Hold on. All right, he's saying, is there anything else before?
For me, it's necessary. Let me just take 5 minutes.
Yeah, he's looking at his little laptop. Yeah, he was looking down at his laptop. So I don't know. It was a judge. I have no idea what he was looking at his laptop. Maybe he was looking at his ruling. Maybe he was looking at something else. I really have no idea. I have no idea. But it was the judge. Michelle, if I was a juror, I would like to hear that fact. Well, that's the problem. It's not a fact. I think that's the problem. And it was and Mr. Bloodworth said in the vetting, "Hey, Sure Life, good to see you." Mr. Bloodworth said the state or the law enforcement, anyway, somebody on the prosecution side checked into Mr. Norris, vetted him, and he called after this motion was made, and I guess somehow they know that the defense told him to call. So it seems pretty sus, suspicious that he calls after this ruling, right? So. Awesome Potamus, good to see you. It still doesn't explain the leftover pain meds. Butterfly, are they trying to say that because he was working at the mansion, his back then was hurting and he needed pain pills because of it? That's not what I'm getting at. That's not what I'm getting. Because that's not what if that's what they're driving at, no, that's not what I'm getting. I'm getting that they're trying to say that law enforcement didn't check into this any further, that maybe he was okay with this mansion. Remember, we've heard that before, that Eric worked with Kouri, so he was okay with her spending money. I think maybe it might be part of that. What else? Yeah, I think it's more that, because we've heard this a couple times, that Eric was at the Midway mansion, and it seems like they're trying to say, the defense is trying to say, well, because he was at this mansion, he was spreading gravel, he was helping her, build it up. He knew that she was trying to flip it. He knew that she put money into it. He knew these things already. That's what I think they're getting at. I could be wrong, but that's what I think. Let's see. Do you pronounce that baby? We'll go with baby. The defense is creating things to confuse the jury. They sound desperate. Isn't that what they always do, though? Hey, Sigi, how are you? Good to see you. Mike Kennedy, there is other ways to get this information in for the defense. Well, they can't bring in this David Norris because it's been ruled upon. So they can't bring that in. Christy, good morning to you. Sure Life, I just think the defense team is so grabbing at straws and behind. They are doing anything and everything they can to throw doubt. That's what they do. I mean, in every trial, we always say that. And it's true. I mean, throw spaghetti against the wall, muddy the waters. We say that every trial. Hey, Mona, they are trying to say the victim did it because of poor investigation. Jaded Wonder, did Carmen ever say she put at the mansion? I think it was the little house. I think it was always that little house. Did she say she went to the mansion? It was always that little house. And the fourth time she went over to Kouri's, I think it was in the driveway. I think it was just the little house. I don't think she did anything at the. I could be wrong, but my recollection was it was the little house. I could be wrong about that, but I'm pretty sure it was not. Dina, good to see you. How are you? Garden Critters, is Midway the same place where Carmen left supplies? There's the Midway mansion, and then there's the Midway little house, right? I think they're both Midway. Let me see. So there's the Midway mansion, and then there's the small house in Midway. So it's both. They call it the Midway mansion, and then it's the small house in Midway. So they're, yeah, she did it. Let's see. She dropped the pills off in the closet, the fire pit. Yeah, I don't think the mansion was involved. I don't think the mansion. So it seems like they're both in Midway. I don't know that area. So if you guys know that area, but it seems like they're both. They called them both Midway. Midway mansion and small house at Midway. So, hey Sarah, weren't there texts from Eric to Kouri about the mansion saying we aren't doing that right now when she was asking for estimates? She asked for estimates. Yes, that we saw that yesterday, Sarah. Yeah, we saw that yesterday, and she said 4 million. Can you estimate it? And he was giving all these other estimates, but he ultimately did do some work over there. He did do some work, and I think Cody confirmed that as well. Pretty sure Cody said that as well. Downey Lynn says, did Eric make it to bed even? He made it to the bedroom at least. He was found at the foot of the bed. His head was facing the foot of the bed. When a person passes, make sure you guys, hey guys, just make sure you misspell certain words, all right? We can't, YouTube's going to smack us, so going forward, just misspell. OD, especially that severe, wouldn't they have some out of a mouth or something? He just laid there. No, well, when they pumped his stomach, I'm sorry, when they gave him CPR, that's when he was vomiting blood. So it wasn't present when he was, when they came in, but when they gave him CPR, that's when he started to vomit blood. Hey, rock and roll, good to see you. He was delivering gravel to the mansion. He was delivering gravel to the mansion, wizard. To the mansion. Amber, yeah, Emmy testified. Amber, the medical examiner testified pretty early. Day two, Pamela Sue Ulmer. And so the foam most likely came from OD, but it could have been from CPR. So she was saying that yes, there was foam, but she thought, remember, Kouri's like, they're giving him CPR and he's, blood's coming out. So she said it could have come from an overdose, but it could have also come from CPR. So her cause of passing was drug intoxication of fentanyl, heavy lung and foamy edema. So the manner could not be determined, but the cause was the fent. So he didn't have a heart attack. His heart was in good condition, actually, she said. Wizard, why would he deliver to a house that wasn't closed on yet? Well, they're fixing it up. They were fixing it up, right? I think they were just fixing it up. Mrs. Baba Yaga, so how do we even know that Eric was even on the bed to begin with? We don't. Maybe he was on the floor after the ingestion. That is correct. Only Kouri's word. That is correct. I'm trying to figure out how she got him. He's probably a pretty muscular dude, right? He was active. He was I don't think he was, a 150-pound guy. I think he was probably close to 200 or 180, 190. He seemed like he was pretty muscular. So he seemed like a pretty built guy. Kouri doesn't seem to be. She's kind of slight. So the EMS or the dispatch is saying, get him on the floor, get him on the floor. And she wrote in that journal or whatever, her statement. She's like, even though I knew it would hurt him, I pulled him off the bed and all that stuff. And then he was laying, flat on his back. His head was facing the foot of the bed, and he wasn't perpendicular. No, I'm sorry. He was parallel. He wasn't perpendicular. So if the foot of the bed is here, Eric's head was here. So he was like this. He wasn't like that. So she pulled him off of his side and then got him around to the foot of the bed. That doesn't make sense. That doesn't make sense. I don't know how tall he was. Did they say how tall he was? I don't think they said how tall he was. Did we get a I don't think we got a height and weight. I don't think we got a height and weight with him, which is kind of a shame. I don't think we got a height and weight with Eric. Usually we get a height and a weight, but we didn't get that. Not that I see. Fanny, we would have heard a thump if she pulled him off. I think so too. That would have been his feet, his back, his head. I mean, I don't know how she did that, to be quite honest. Iowa, regarding the Monster Mansion, they were planning to close the purchase, so we're probably given the okay to do some things, but not actually owning it is wild to me. Sorry, I got cat fur. Rock and roll. I wonder if it would be spicy today. Yesterday didn't get spicy. Jadzia Dax, was the sheet under him? I think so. I think it was. If so, that seems to support that she did use it to pull him off the bed as instructed. I'm pretty sure. Let me double check. I'm pretty sure I took a photo of that. Not to be graphic. I'm not going to be graphic with you guys, but I'm pretty sure. Well, I think it's him. I think the sheet is over him, but let me check. I'm pretty sure I took a photo of that because of this very question. I just have it with the sheet over him. Unfortunately, I just have it with the sheet over him. I don't think there's, trying to think what the EMS said. Was there a sheet under him or over him? We've heard that in testimony, and I can't remember right now. Hey, Gordon. Garden Critters. Could she have pulled him feet first off the end of the bed? She could have, but she's on the phone call. She's on the 911 call with dispatch. Don't forget, we heard all of that. It doesn't sound to me like she's grunting and plus she's got the phone. However, she has the phone. It doesn't seem like she's doing it, in my opinion. Oh, here we go. Judge is coming back.
On the record in 231-500-139. Counsel, thank you for your patience. I've just handed you a copy of State versus McCullough, 2014 UTF 215. I need you to take 15 minutes, read this case beginning at paragraph 25. This case stands for the proposition that what the defense is proposing to do is required, but it raises the prospect of also allowing the state to rebut the defense's charge of an incomplete or improper investigation by also putting in evidence, not for the truth, but for the effect it had upon law enforcement, of how they received and reacted to Hayden Cheff's statements to his sister. Pause for a second. I need you all to be very thoughtful about this. I can't unring the bell once this information is out and sitting here at the moment, without the benefit of counsel's argument after reading this case, I think I'd have to let both sides of that story in to make sure that the state is not prosecuting with one hand tied behind its back. Mr. Bloodworth, I cut you off.
Sorry, Your Honor. We looked at this case while you had stepped out. I think in addition to Hayden Jeffs, it would also cause us to revisit the court's decision yesterday regarding Mr. Bonsavage's phone call with an inmate at Gunnison.
Ooh, I don't remember the detail of that one. Forgive me. Oh, I think I do. Yeah, a little bit. Now, let's talk about foundational requirements. I gave this a little bit of thought after rereading McCullough. There is some precision and some technicality into how these questions would need to be asked. For example, Ms. Nestor, you wouldn't just be able to put the substance of Mr. Norris's statement in a question and ask whether Detective O'Driscoll ever followed up on it, because you would not have laid foundation that he ever knew about it in the first place. You need to lay foundation about whether or not he ever spoke to David Norris, yes or no. If no, did anybody ever relate to you that David Norris contacted the Summit County Sheriff's Office, yes or no? Yes. Okay, after that, what did you do? This information, this statements being made by David Norris to Summit County Sheriff's Office have to come in through a witness with knowledge of them. And I'm not sure Detective O'Driscoll's that guy. By the same token, to the extent the state would want to ask or show that the investigating officers or the Summit County Attorney's Office investigators followed up on statements made by Hayden Jeffs to his sister, Aubrey Jeffs, or information received or is told by Mr. Bonsavage, they're going to have to call a witness that had personal knowledge of those statements and then lay foundation for what occurred next. We can't skip steps.
Your Honor, agreed. There's a little more to unpack here, too. Because I happen to know that Jeff O'Driscoll's not the witness for this. We would need time to prepare the witness for this. We also have the problem that
We meaning
the state.
The state. May I ask you just a procedural question before you keep going?
Yes, sir.
Imagine that at some point, imagine it's not Jeff O'Driscoll, as
Right.
you suggest.
Right.
And imagine in the defense's case, they find or call the witness who received the phone call or talked to David Norris, or they call David Norris.
Sure.
And they ask, did you
Sure.
call Summit County Sheriff's Office? Yes. What did you tell them? Did they ever follow up with you?
Yes.
I imagine the state's response to this and the state's offering evidence regarding how it responded to information regarding the Hayden Jeff statements and the Nick Bonsavage statements, that would come in the state's rebuttal case. Is that correct?
Not necessarily, Your Honor. I mean, we haven't rested. I think
Fair.
we would like to get out in front of this
Okay.
before a rebuttal case. And while the state has investigated David Norris's statements and to show how they're not credible, the state pulled up on investigating how Norris came about. And the state would want to continue that investigation.
I think I know what you're talking about, but in terms of how it came to be that David Norris contacted law enforcement when he did,
Correct.
I don't know that I have any authority or interest in ruling.
I don't think you.
Yeah.
I don't think so. My only point in mentioning that is it would just take a little bit of time, and it would be necessary. The other point, I think, well, the other objection the state has is under 403. I think in proceeding in this manner is both prejudicial and confusing the jury.
If I let in everything, though, so Norris, Jeffs, Savage, does that ameliorate any unfair prejudice or 403 concerns? And when I say let it in, I mean as premise for questions regarding the scope of law enforcement's investigation, not for the jury.
I appreciate that, Your Honor.
I tend to agree with you if I let in only one side.
It's interesting because both that assumes that the weight of unfair prejudice or the weight of confusion is equal on both sides. The state, I don't think it is. I think because of the complete incredibility of David Norris's testimony and how David Norris came to contact law enforcement, that prejudice and that confusion is much weightier than confusion related to recorded interviews with Hayden Jeffs while he has counsel and a recorded jail phone call. There is no doubt.
Doesn't that weigh in the state's favor, though?
No, Your Honor, because I guess the question is whether it's unfair prejudice or confusion. Confusion, it doesn't, David Norris's the purported effect on law enforcement of David Norris's is even way more confusing than the effect, just because the information provided to David Norris is highly in doubt and would be highly litigated, whereas the information Hayden Jeffs provided is recorded. There is zero doubt about what he provided. And the information that Nick Savage provided is recorded. There is zero doubt. We're not bogging down into some mess of who said what when.
When you say the information, you mean the substance of what David Norris told Summit County Sheriff's Office a number of weeks ago?
Correct.
Okay.
Because it's changed. It has changed over time. We have affidavit number 1 from defense, affidavit number 2 from defense, phone call from David Norris, interview of David Norris. What David Norris says is a moving target, and it is a moving target based on when he speaks with defense counsel.
Forgive me. What is your understanding of the evidentiary landscape as to how many times David Norris has contacted the Summit County Sheriff's Office? Is it once or more than once?
I think he's had 2 contacts. Once he spoke with a patrol deputy to take kind of the initial, I guess there's once a call into dispatch, which was non-substantive.
Okay.
Then there was an initial contact with a patrol deputy, and then there was a contact with a detective.
Okay.
And then we have the affidavits that he'd submitted, that defense has submitted in the 807 litigation.
But those were submitted here, right, as part of the 807 litigation. Did those ever go to Summit County Sheriff's Office?
I don't know one way or the other.
If it's no, then those don't get shown to the jury, right?
Just to clarify, they weren't affidavits. We just laid out a statement of facts in our motion.
Okay.
It's a proffer.
I'm familiar with what you're referring to. I'm a little less clear on
Sorry,
that. Yeah.
proffer is, proffer is the...
I'm not sure the proffer has any impact here. I'm not sure the jury would ever be made aware of the substance of the proffer. They, as I understand it, under McCullough, would only be made aware of evidence related to the substance of what Mr. Norris told investigators and law enforcement.
Your Honor, the proffers do tie into this in that the question would be, did this inform your investigation? Yes, we considered all of his statements to include the defense proffers in determining that they were just flat out incredible.
Okay.
So that goes to kind of the confusion argument. So in the 403 analysis, Your Honor, I do not think the weight of unfair prejudice to the defense is the same as the weight of, well, any of the 403 factors. I don't think the weight is the same for the state and the defense.
And to put a finer point on it, you're concerned that the jury would be confused about who said what when? It's jury confusion that I need.
It's jury confusion.
Right. And
yes.
so what is it you believe they would be confused about?
I think they would. I think they would be confused about the effect on law enforcement, which is really what this grounds in, right? This is the effect on the hearer, the effect on law enforcement.
Okay.
And I think those waters would be so muddied in the case of Norris, whereas those waters are crystal clear in the case of Hayden Jeffs and Nick Bond-Savage. And the waters are muddied as it relates to Mr. Norris very deliberately. And that and I don't know that. I suspect the purpose is to confuse the jury, right?
As you sit here today, have you identified the witness that would testify regarding investigators' knowledge of and response to statements made by David Norris?
I know. Yeah, I don't remember the name. I know the patrol officer. I think I know who he talked to. I think I know who the detective talked to. It also involves my office, right? And so
You would be able to call an investigator, not a lawyer, right?
right.
Yeah.
So probably 3 witnesses.
Okay. And then who are the witnesses you would call to testify regarding the state's knowledge of and response to Hayden Jeff's statements to his sister? Or, I mean, I appreciate that Hayden Jeff spoke directly to law enforcement in a recorded interview.
Right, that's what we would have to get into. What did you understand, why, with what level of detail, which is extraordinary.
And there, as I understand it, the state's position would be, well, if we're not admitting it for the truth, Judge, there's no Crawford problem, so the recorded interview comes in.
100%.
Okay.
And the same thing, by the way, with the Nick Bond-Savage jail call, right? That entire jail call comes in lock, stock, and barrel. If we're going to mention it, we're going to mention it all.
Oh, I understand.
And then can I just say one final thing on the unfair prejudice? I think the court, in considering the weight of the various prejudices, the prejudice with admitting Norris, versus the prejudice of the Hayden Jeffs and Bond-Savage, I think the court needs to in the probative value part of that analysis, I think the court needs to consider kind of all of the corroborating evidence and the fact that David Norris's assertion is not at all probative, because there is nothing that corroborates it, and it is inconsistent with all the other evidence in the case, whereas the Bond-Savage statement and the Hayden Jeff statement is highly corroborated with all with a ton of admitted already evidence in this case.
And just so we're clear, when you're talking about probative value in this context, we're talking about probative value to the defense's theory of incomplete investigation and probative value to the state's response to that theory.
Correct, under the 403
Got it.
balancing.
I understand your position.
Okay.
Ms. Lewis, Ms. Nestor, Mr. Ramos, this is high-stakes poker.
Yes, it is. I was just going to ask you if we could have a little time to meet with our client next door. She's got some decisions to make about that.
I want to make sure that you explain to her that if you're successful in persuading the court that the substance of David Norris's statements should come in not for their truth but for their effect upon law enforcement and investigators, for their probative value to the defendant's theory of incomplete or incompetent investigation, that by extension, my view is that I need to allow the state to respond to that theory by, among other things, admitting evidence of their knowledge of in response to statements made by Hayden Jeffs and Mr. Bonsavage, not for their truth, but to show what they were doing and how they were doing it.
Can I just get a clarification on the Bonsavage? I want to make sure I'm on the same page.
Why don't we just get a proffer of it, Mr. Bloodworth, so we're all hearing the same thing at the same time?
Yes, Your Honor. In a March 4th, 2022 jail call between Mr. Bonsavage and an inmate in Gunnison, they're discussing purchasing a PlayStation controller, and they're discussing who's going to pay for it, kind of how to get the money for it. And Nick Bonsavage says to the inmates something like, Carmen will cover it. She just made money selling fentanyl.
So this is already in, other than we
word
substituted the word fentanyl
We
for
illicit
illicit
street drugs. Right. And that's a recording,
It is a recording.
as is Hayden Jeff's interview with law enforcement.
And the upshot proffer of that interview, and this occurs many times, there's pages of transcript on this subject, but the upshot of the proffer is that Kouri Richins asked me to buy her fentanyl. I explained to her, in really colorful language, how dangerous it is. She wants to stay away from it. Who on earth would want fentanyl? And then there's a second phone call where she calls back and asks for the Michael Jackson stuff, and they get into a propofol discussion.
Right. Okay. How much time do you want, Ms. Nestor?
We have 30 minutes.
It's fine.
Thank you, Your Honor.
Anything else before we take a recess, Mr. Bloodworth?
No, Your Honor.
Ms. Nestor?
No, sir.
We'll be in recess until 10:30. All rise.
All right, they're taking a break until 12:30 Eastern, 10:30 their time, 10:30 local time. All right, so what the judge ultimately, remember, we're like, oh my gosh, what's he going to do? He looked at something. He's taking a 5-minute break. He's going to come back. So ultimately, what he had discovered was a case law that is going to allow the state, if the defense is going to bring this in, if he's going to allow the defense to bring this in, then he has to allow the state to bring in to counteract that. And that means bringing in Hayden Jeffs, apparently his phone call, or his maybe his comments with his sister. And then there's this Nick Von Savage phone call with an inmate about the PlayStation controller. And yes, that did come in yesterday. There was some talk about this PlayStation controller with O'Driscoll. Let me see if I can find that. Let's see. There was something yesterday with O'Driscoll talking about this PlayStation controller. I do remember that. Let me see if I can find that. Shoot, I can't find it. I thought it was... Maybe he's here. Nope. There was definitely something about that yesterday that Carmen can pay for it. Oh, he said Xbox. All right, so requested inmate calls with Nick and heard conversation about an Xbox purchase. So he said Xbox. So he was talking about his investigation. Okay, so that's what came in yesterday. So Detective O'Driscoll was asked, tell us about your how your investigation led to Carmen. So he said it was a long process. They got the autopsy results. They checked phones, frequently contacted numbers, and they saw Carmen's number. So he said he knew Carmen from before. They had interaction with her before. And Nick Von Savage was in court with Carmen. He requested those inmate calls between Nick, and he heard this conversation about an Xbox purchase. And that took place March 4th of 2022, in which and then now we're finding out that he said, oh, Carmen can purchase it. She just made money selling at Fent. So it was Xbox versus PlayStation. So there you go. All right. So to recap, the judge listened to these arguments. Defense wants to bring in this question about